is therefore essential for all organizations to understand what readiness truly means in practice. We are privileged today to have with us two distinguished experts to guide us through the
Okay.
nuances of this
Diksha doesn't have
transition.
presentation. Can you give it to her?
Mr. Anshul Prakash, partner Khaitan and Co.,
Yeah.
and Abhinav Rastogi, partner Khaitan and Co.
You
Abhinav Rastogi
send
is
the
a partner in the
limited shares
employment.
to her also. Okay.
Uh, Anybody who is not speaking, can you kindly be on mute? Thank you. Abhinav Rastogi is the partner in the employment, labor and benefits ELB practices at Khaitan and Co., Delhi. He advises clients on a wide spectrum of employment law and compliance matters, ranging from complex workflows restructuring, retrenchment and establishment closures to business transfers, disciplinary proceedings, POSH issues, and drafting of employment policies and contracts. Abhinav's expertise has been widely recognized. He's ranked by Legal 500 as a recommended and key lawyer 2025, named an Asia Law Distinguished Practitioner 2025, and previously recognized as a notable practitioner 22-24. He was also listed by Legal 500 as a next generation lawyer for labor and employment from 2016 to 2009. A very warm welcome to you, Abhinav. Let me also introduce the second speaker. Mr. Anshul Prakash is a partner at Khaitan & Co. and leads the firm's employment, labor and benefits practice from Mumbai. He's widely recognized as one of India's leading employment lawyers with multiple accolades from Business Today, Asia Law, Legal Era, Forbes India, and HR Associations of India, among others. Anshul advises leading domestic and global organizations in the full spectrum of employment and labor law matters, workforce strategy compliance, industrial relations, workplace benefits, investigations, and business transfers. He's also regarded as a key expert on the newly enforced labor codes, advising clients on implementation, compliance readiness, and policy transitions. A respected voice in the industry, he regularly contributes to thought leadership and speaks at forums hosted by NATHEALTH, CII, ASSOCHAM, HRFI, IFCCI, and other leading bodies. The extensive experience of both our speakers in labor, employment, and regulatory advisory makes them ideal speakers to walk us through the operational compliance and strategic implications of the codes. We thank you once again to all of you for being here. Please feel free to engage, deepen the conversation, ask questions, and we look forward to insightful, practical, and action-oriented discussions. With that, I invite our speakers to begin the sessions. Thank you.
Thank you, Mr. Bhattacharya, for the kind introduction. I'll just quickly cover the objective of today's session, which is essentially meant to take you all through the key provisions of now enforced labor codes. And of course, if you have any questions, just feel free to continue to post them in the chat box. We will endeavor to address each one of those at the end of the presentation. So all the relevant aspects are meant to be covered by us. Now, quickly looking at the enforcement part, Mr. Bhattacharya has covered that aspect about labor codes now being enforced. 29 central labor statutes are now consolidated and replaced by these 4 labor codes, which are in the specific domain of wages, social security, industrial relations, and occupational safety, health, and working conditions. And the nuance here is that while the labor codes have been formally brought into force, the practical implementation of several key provisions continue to remain contingent on issuance of detailed central and state rules. Now, these rules will prescribe the operative processes, salary thresholds for specific coverage for employees in a specific category or in general under certain chapters, ceilings on some statutory payouts for the new codes to function in practice. So as a result, only those provisions that are self-contained and not dependent on the rules can practically be implemented. Now, some of these include definition of wages for computing statutory payments, timeline for payment of wages, prohibition of contract labor in core activities, and some other relevant aspects. Just to clarify a few aspects before we move ahead, there's a lot of frenzy in the market. Most of the time, we have been hearing that, what do I need to do? Am I going to be prosecuted? Is the authority going to come after me? Just wanted to put things to rest here that there is no need to panic. In the next few months, organizations are required to assess what changes are immediately implementable, what can be reviewed at a later point when governments have done their own part of rolling out the rules, schemes, notification, and of course, hopefully some of the advisories to bring in further clarity on some of the confusing elements. The central government itself has also issued a statement, although it's not a writing on the wall, but it's an assurance that to the extent certain aspects are left to the state governments and central government to implement, the regime that has operated so far on the procedural side will continue to remain effective. Now, moving on to the next slide on Code on Wages 2019, and proceeding to this very critical statute, which has replaced Equal Remuneration Act, Minimum Wages Act, Payment of Wages Act, and Payment of Bonus Act. So in the coming slide, what you see is about the fundamental concept about what exactly is wages under the Code on Wages, or generally under the Labor Code regime. And this has been one of the most talked about provisions. Putting simply, wages refers to all remuneration that an employee receives in ordinary course in return for the work he or she does. And of course, there are certain express exclusions from the definition of wages, such as conveyance allowance, value of house accommodation, house rent allowance, commission, etc. Now, to understand the concept of wages better, and this is something which you all need to really focus on. A lot of reports in the media about 50% of CTC, 50% of this or that. We need to restructure. So the idea here is to dispel some of those misconceptions on how do you interpret wages under the code. So to understand this concept, wages would include all promised payments to the employee under the employment contract in return for the work ordinarily required to be performed by an employee. So any discretionary payment would not fall within the purview of wages. Likewise, any payment which is contingent on the employee fulfilling certain parameters, meeting certain specific conditions, or the payout is contingent on occurrence of an event, those components, those payouts will not form a constituent of wages. Also, any performance-based incentives which require employees to perform a task or would have to go beyond what he or she is required to do under the employment terms is not a part of wages. Continuing from that, when we look at the larger premise on how do we see the compensation structure, which you see on the slide right now, in respect of the codes. Now the cost to the company will consist of two items. One, the remuneration which is earned by an employee. Two, other costs incurred by the employer in relation to the concerned employee. Now within the category of remuneration, there is further bifurcation into wages, that means the included components, and those components which are expressly excluded from wages under the codes. So what the codes would state is that if the wages bucket is not 50% of the total remuneration paid to an employee, then it will be deemed by the law that wages bucket is indeed 50% of the remuneration, specifically for the purposes of computing wage-linked payouts. So just to again clarify, this proviso which I'm referring to does not require any change in any mandatory change in the remuneration structure. It only impacts certain computations such as gratuity, retention compensation. For example, and I will cover the gratuity part in terms of how this computation is going to be covered. My colleague and partner Abhinav is also there, so he will cover it under the Code on Social Security. But when it comes to gratuity, the employer will have to ensure that computation is made on at least 50% of the total remuneration. Now, where the wages bucket is already more than 50% of the remuneration, then that computation will have to be made on the actual wages. And that is, of course, subject to the payment cap that the central government will notify. So for now, as we have already mentioned in the beginning of the session, the ceiling that has been applicable so far on payment of gratuity, which is 20 lakhs rupees, will continue to apply until a new ceiling is notified by the central government. So for payments such as leave encashment, notice pay, what is important for all the participants here to understand is that harmonization between state and central laws will have to be carried out, because there are existing laws from state jurisdiction perspective. None of the shops and commercial establishment legislations have been repealed when the code on wages and other codes have come into force. Continuing with this and moving on to the next slide. Now here what you see is an example to show how remuneration is structured under the code. So you would see on the slide basic salary, dearness allowance, medical allowance and education allowance would all form part of wages, the included category. So by now you also know, and we have already mentioned, house rent allowance and conveyance allowance would be expressly excluded components. Now in this example, which we have shown on the slide, the wages bucket is less than 50% of the total remuneration, which is of course the sum of wages and the expressly excluded components. So in this case, what the code would notionally do is to take certain percentage, certain portion from the expressly excluded components and add it to the wages bucket to bring it up to 50% level. So this is how the code would essentially construe how the wages have to be carried as a threshold for some of these wage linked payouts. It is not specifically asking anybody to restructure. It's just about ensuring that when you are computing these benefits, how are you considering wages for your employees? Continuing on the next slide about some other key changes under the Code on Wages 2019. So in this slide, as you would see, the minimum wages that were prescribed only for scheduled employments. Now we have the concept of a national floor wage, which would be set out by the central government. And states, of course, may fix their minimum wages at or above this level. And minimum wages will be prescribed for all kinds of employment. So recent discussions with the central government and some deliberations which have been ongoing also suggest that different floor wage may be notified by the central government for various states because of the potential anomaly which may exist in relation to how the economic standing of each of the states would vary. So to have a uniform wage concept, at least at the floor level, may not be the most economically viable option, but we have to see how this really is transpiring. Now, the code has also done away with the wage ceiling that applied so far on Payment of Wages Act, which was 24,000 rupees per month. So the provisions relating to timing of payment of wages during and post cessation of employment, permissible deductions from wages, all of it will have to be adhered to for all employees, including managerial personnel. So just to clarify, there is no differentiation between status or categories of employees. It is an all-encompassing application. All the employees are going to be covered, notwithstanding the nature of duties, notwithstanding the salaries they are earning. But I think the most critical point which has been doing the rounds is the timing of full and final settlement, because there's a lot of discussion which we have heard, reports that have been coming in that every organization will be required to do full and final settlement in 2 days, 2 working days. So I would like to just clarify the point that this 2 days, 2 working days timeline is for disbursement of wages. And it is not something which is applicable to all kinds of payouts, exit payouts. So gratuity has its own timeline. Retention compensation is not included as part of wages. Again, if there is any other payout which is outside the purview of wages, you can continue to pay that separately, including any long-term incentive plan benefits which are accruing to the employee. So the point is that you don't have to look at everything to be included when this settlement is being done. It's all about wages. Needless to mention, the law also specifies a possibility wherein the central government may notify specific scenarios or specific conditions which may be required to be met. Also, it cannot undermine the possibility where wages may not be immediately dispersed if the concerned employee himself has not adhered to some of the key requirements or obligations on his part, including return of assets or any equipment which may be in his custody. Another important point is about statutory bonus threshold, which will be notified separately by the appropriate government. All other criteria and bonus rates, which is of course ranging from 8.33% to 20%, remain unchanged. One important point, conviction for sexual harassment of an employee is now a ground for disqualification as far as eligibility to receive statutory bonus is concerned. So this is an important point, and it has been specifically added in the relevant chapter under the Code on Wages. Last and very important, the focus now is on gender. It is not on sex. The law does not talk about male or female employees for the purpose of ensuring equal remuneration for equal work. It focuses on non-discrimination on grounds of gender. So even transgender persons have been included by way of this reference along with male and female employees for the purposes of ensuring equal remuneration for employees. So this brings the session on Code on Wages to an end. I'll hand it over to my colleague Abhinav. Abhinav, over to you.
Thank you, Anshul, for such crystal clear explanation on definitional attributes of wages, which is one of the most important concept. I'll be taking you through the slides on Code on Social Security and Industrial Relation. So the Code on Social Security 2020 has replaced 9 extant central statutes, the prominent one being the ESI, EPF, Maternity Benefit, and the Payment of Gratuity Act. While the SS Code and OSH Code have made registration requirements for covered establishment mandatory, this does not mean that existing registered establishments will again have to obtain registration certificate. The code provides that whatever registrations have been obtained, they would suffice for the time period right now. And the rules may require some of the additional details to be submitted subsequently. We can move on to the next slide, please. Sure. So as my colleague and partner Anshul emphasized on the definition of wages and how it is going to impact employee payments, such as gratuity, leave encashment. As far as PF is concerned, we all know that there is a statutory ceiling threshold which is prescribed currently at 15,000 rupees. To that end, we do not see that any restructuring would be needed, at least from PF liability standpoint. While we do not know that what the new wage ceiling would be, but there are conversations or there are press media releases that it could range from 25,000 to 30,000 rupees. So that is on the wages part. Then another important notable change here is inclusion of contract workers in the definition of employee. So in the erstwhile scheme, you would all be aware that it was limited to EPF and ESI. However, now contract workers are also included in the definition of employee, even for the payment of gratuity. So now essentially as a next step, what one needs to understand is that they need to revisit the contractual agreements and can contractually agree to make the contractor primarily responsible for these payments and ensure that the principal employer's interest is ring fenced from that standpoint. So a key aspect to do right now is to understand what your contract work arrangements are, what the contract stipulates, and next step could be to ring fence that. Now, the other important concept which has been introduced is about recognition of fixed term employment across establishment. Earlier, the engagement was expressly recognized in model standing orders and contained in central rules. Also, there was certain specific industry like apparel and clothing where fixed term employment was recognized. But now irrespective of the nature of establishment, fixed term employees are entitled to at par treatment in employment terms with permanent employees who are doing the same work. So akin to your permanent employees, fixed term employees are also entitled to same benefits. This also means that they will be entitled to gratuity in case of contract expiring prior to the completion period of 5 years. Of course, this would have to be paid on a pro rata basis for the time spent in an organization. So, other than that, there are certain other changes with regard to allowing employers to avail crèche facilities from third parties and introducing a limitation period of 5 years. Slide, please. So now, what are the takeaways for this transitionary phase for us? As Anshul discussed, the definition of wages has been made effective from a social security contribution until we have the revised threshold. The contribution and the payment ceiling for gratuity and EPF continues to remain as per the erstwhile scheme. And the second one is that the substantive provisions of fixed term are not contingent on government rules and notifications. So organization can initiate a review of their current engagement practices as far as entitlements of fixed terms are concerned. So this is on the transitionary phase. Also about the contract labor, what we just spoke about or what we discussed about inclusion in the term employee. So from that perspective, contractual service agreements could also be kind of revisited to understand what the liability is. Next slide, please. So now we come to Industrial Relation Code. So Industrial Relation Code would subsume three statutes, namely the Trade Union Act, the Industrial Employment Standing Order Act, and the Industrial Dispute Act. Slide, please. Sure. So definition of wages is similar to what has been discussed already. That was one of the core concepts to have uniform definition of wages. And we've already discussed the implication of that definition, including on computation of retrenchment compensation for termination of employment of a non-managerial employee. So the definition of wages remains uniform across the codes. So that is one. But here for under the industrial relation, we would have to apply this definition for the purpose of calculating retrenchment compensation for non-managerial employees. The next one is about the Industrial Dispute Act and Industrial Standing Orders, which apply to workmen. The Industrial Relation Code also applies to workers. There is no difference. Earlier, the term used was workmen, whereas now the term used is worker, with only difference is that in the erstwhile scheme, the employees who were in supervisory capacity earning wages more than 10,000 were covered. Now, while were excluded, now the workers would exclude supervisory employees earning wages more than 18,000. So except for the threshold, which was erstwhile 10,000 rupees, now it is 18,000 rupees. There is no difference between the two definition. Earlier it was just called workman, now it is just called worker. Now moving on to the next one is with regard to standing order, which governs certain aspects of employment of non-managerial employees, such as their disciplinary process in case of any misconduct, but it had limited applicability as it applied to only industrial establishments such as factory, mines, having a threshold of 100 or more non-managerial employees. Uh, Few states had kind of reduced this threshold, and few states had already also extended this statute to commercial establishments. But now the chapter on standing order under the IR code applies to all commercial establishment crossing the threshold of 300 or more non-managerial employees. So now these larger commercial establishment would either have to comply with the model standing orders, which are released by the central government, or get their own model or get their own standing order certified from the certifying authority, which will be the state government for most of the private employers. The next one is about the grievance redressal committee. The ID Act did not make it mandatory for an employer to set up a GRC, a grievance redressal committee, if there was a grievance redressal mechanism already in place. However, the IR code makes it mandatory to have such a committee consisting of employer and employee representatives. The decision of the committee would have to be made on the basis of majority view, and such majority view would also encompass that more than half of the members representing the workers agree to such view. Otherwise, it shall be deemed that there is no decision which could have been arrived by the committee. Next slide, please. So, as you would all know, that there were certain restrictions around restriction in the sense that prior approval was required for every factory, mine, and plantation having 100 or more workmen prior to retrenching, closure, or layoff any non-managerial employees. Few states had increased this threshold, but now this threshold has been uniformly increased to 300 or more workers, although the approval requirement continues to apply to factories, mines, and plantation. So just the threshold difference has come, and there is a lot of because of this threshold being increased, there is a lot of trade unions backlash on this specific aspect, because they would want that this would give private employers a lot of flexibility to retrench or to close down operations, whereas earlier they required specific approval. So this is one of the notable change which have been brought out under the code. The IR code also introduces an additional requirement in terms of contributing towards the reskilling fund. In the under the industrial or the current regime, there was no concept of reskilling fund, but now every employer who's kind of retrenching non-managerial employees, they're also required to contribute a certain percentage of amount towards the reskilling fund, which is calculated at 15 days wages. Please note that the retrenchment is calculated on the basis of 15 days wages for each completed year of service. Here, it's only the 15 days wages which needs to be deposited. So that is another financial implication, I would call, for employers who are trying to retrench, or additional costs which they have to warn for retrenching workforce. The next one is one of the most notable and welcome change in terms of trade unions. So few states like Maharashtra, Telangana, Maharashtra had one of the most strict laws in terms of recognition, the MRTP Pulp Act. But mostly the states did not have any recognition mechanism. Through the code, recognition of trade union has been introduced throughout the territory through a verification process. So a trade union or a group of trade unions will become a negotiating union council after the process of verification of worker representation is done. And they will have the right to collectively bargain with the employer. So what it essentially means is that where there is only one registered trade union, the same would be considered as sole negotiation union of the workers. where there are more than one registered trade union, the one having 51 or more percent of workers of the establishment shall be recognized as sole negotiating union. But where there are more than one registered trade union, none of which has 51% of more representation, then there will be a negotiating council, which would consist of representatives of these two or more trade unions, which have the support of 20% of the workers. So the harmonization would take time with regard to the state-specific rules, but this is the new concept of which has been brought up through negotiating council. And towards the last one is about the strikes and lockouts, which were erstwhile applicable only in public utility services. Now these restrictions also uh, are applicable to private employers and to all kind of establishment to say that you are required to give 60 days prior notice before taking any action and a cooling period of 14 days. So this is with regard to lockout. Next slide, please. Sure. So what are the key takeaways for the transitionary phase? Employees to be mindful. The definition of wages to be reckoned for the purpose of calculating retrenchment compensation. Other aspects such as your reskilling fund and adherence to new standing orders are all contingent as of now on the state rules. So as such, the current regime under the central model standing orders or the current scheme would continue to prevail under the code. I will now pass the baton back to Anshul.
Thanks, Abhinav, for that insight on the two critical codes. But I think I will try to cover one of the most extensive ones, which is Occupational Safety, Health and Working Conditions Code, because this code, this statute has replaced as many as 13 pre-existing central statutes. Primary ones, of course, are the Factories Act and Contract Labor Regulation and Abolition Act 1970, amongst others. Next slide. Now, before we discuss the key changes under the OSH code, I'll just clarify that most, or I would say significant majority of these provisions under the OSH code will apply only to workers, and that excludes persons who are employed in a managerial capacity or persons who are employed in a supervisory capacity with wages of more than 18,000 rupees per month. Previously, the provisions of Factories Act applied to all employees engaged at the factory. Of course, for instance, which meant that overtime wages had to be paid even to those personnel who are engaged in the corporate setup within the factory premises, and not just to the workers or non-managerial personnel. Now, accordingly, employers would now have a certain degree of flexibility when it comes to managerial employees who are engaged at factories. Also, the definition of worker does not cover contract workers, unlike the previous regime. Also, the present situation, the Sales Promotion Employees Act covers pharmaceutical establishments and any other establishment notified by the central government. So far, the establishments notified include electronics, cosmetics, ready-made garments, automobiles, and electrical appliances. However, the OSH code goes a step ahead and covers all persons engaged in any establishment to do any work relating to promotion of sales or business, provided such persons are not engaged mainly in a managerial or administrative capacity. And of course, again, the same, the definitional attributes, which is the exception for employees who are engaged in a supervisory capacity. So if they're engaged as supervisors and they draw salary wages, which is more than 18,000 rupees per month, then they are again excluded from this purview. So this change is important because there are certain special provisions for sale promotion employees. Now, in addition to the holidays and leaves as may be prescribed by the central government, the sales promotion employees shall be granted, of course, if they have requested for it, earned leave on full wages for at least 1/11th of the period which is spent on duty, leave on the basis of medical certificate at 50% wages for at least 1/18th of the period of service. I mean, doing the math is one thing, but there are specific provisions which are applicable for sales promotion employees. Another key change which is brought about by OSH code is the concept of core activity of the establishment and prohibition of engagement of contract labor for core activities of any establishment. So just to do a recap here, prohibition of engagement of contract labor for core activities as a concept was something which was limited to the state of Telangana and Andhra Pradesh, who had prescribed this whole aspect of core and non-core, and never was the case that it was a subject matter covered by any central law. The whole aspect of arraignment being a sham, etc., evolved through jurisprudence by court precedents, but not under a specific statute. But the OSH code now extends this idea, this whole concept, uniformly across India. So it provides that an activity for which an establishment has been set up, including the activity which is essential or necessary to the establishment, would be considered as a core activity. Just to provide some further guidance on this concept, the code also sets out certain activities that would be considered as non-core activities unless the establishment itself has been set up to carry out any of those operations or activities. And some of these which have been named out is sanitation, loading and unloading of goods, security services, housekeeping and sanitation, transport services. However, contract labor may be engaged by an entity for its core activity if that activity was ordinarily done through contractors. And that is, of course, completely dependent on industry benchmarking. Just to clarify that what you have been doing, let's say even for a decade or so, would not automatically make you fall within this exception. So do that subjective assessment to determine whether these contract workers can be engaged for the core activity and it can be a customary facet of your operation. So it is not just about you, it's for the entire industry or the specific sector you are dealing with. There is a provision under the OSH code which also specifically mentions about a specific mechanism to have the government make inquiries and determine what that core activity is for the purposes of enforcement of this provision, which is talking about prohibition on engagement of contract workers for core activities. The next change is the introduction of working hours, spread over and overtime under the OSH code. None of these subject matters were previously regulated by a central law. And I'm talking about the non-manufacturing units or commercial establishments. The commercial establishments, as far as these matters are concerned, were only governed by state-specific shops and commercial establishments legislations. Now, there is an attempt under the OSH code to create a common working requirement spectrum across India. Since the state-specific shops and establishment laws are not intended to be subsumed by this code, and none of these laws are repealed as of today, and will continue to operate under the extant regime, we'll have to also see how the central and state governments will be consulting each other to reconcile some of these overlaps and differences in the requirements. The number of earned leaves and leave encashment applicable to commercial establishment also varies across states. But now, in addition to these state-specific requirements, organizations will also have to take note of leave entitlements under the OSH code, which provides for an annual leave with wages of 18 days in case of a worker who has completed at least 180 days in the relevant year in any establishment. There is also a 30-day carry forward limit in relation to the earned leave and encashment of excess leave, and also in-service encashment on an annual basis if the worker demands such encashment. So as there are two sets of these requirements, largely on the same subject matter under the central regime and the state regime, from jurisprudential standpoint, the one benefit which is more favorable to the employees ought to be complied with. But just to give you a flavor here, you can continue to comply under the state-specific Shops and Commercial Establishments Act, but until the rules are ultimately notified under the OSH code and there is further clarity, be prepared to at least assess what provisions in relation to employees pertaining to spread over, overtime, leave entitlement, leave encashment are more beneficial under either of the laws. So in case of any conflict, which may continue to exist, let's say there is no specific attempt by any of the central government or state government to reduce this overlap or address this problem, then you have to look at it from the viewpoint of comparative assessment, and that is something which will be of significance for any organization to carry out. Another important point is about specific format. A written appointment letter to be provided to all employees. Template is yet to be seen because rules are yet to be framed by the central government. So once those rules are out, the state rules are out, we have to see if there is any specific information sharing requirement when it comes to the template for an appointment letter. Quickly moving on to the next slide, which is pertaining to takeaway for the transitionary phase under the OSH code. So as now we see from a central regime perspective, there is a clear prohibition of engagement of contract labor in any core activity, which is of course effective as of 21st November. It will be important for establishments to assess the current engagement practices which pertain to engagement of outsourced personnel. Of course, you need to look at the exceptions which are available to you and see based on that assessment if at all there is a possibility of using that exception or taking refuge under that exception. And this is particularly relevant for those organizations who are heavily reliant on third-party manpower service providers. Just to again quickly bring out this point, there is no immediate requirement to overhaul your standing orders. Abhinav has covered this point in brief, but the current standing orders will continue to operate until central model standing orders are released. The certifying authorities are yet to be notified under the code, so the existing regime will continue. There is an overlap, a very evident overlap between few state laws and the codes which are required to be harmonized. Now, one cannot rule out the possibility of state governments bringing in further clarity through rules or even state amendments to the codes, as I mentioned. But if that does not happen, instead of waiting it out, you may have to undertake the harmonization exercise at your end, and that is largely something which is required at this stage, so that tomorrow, if there is lack of visibility on this front, then at least you are prepared to ensure that employees are not losing out on those benefits because of the overlap, and your requirements and compliance as an employer is adhered to under both the regimes that continue to coexist. Similarly, organizations should also assess their leave entitlements, including whether these entitlements under the code can coexist with the state entitlements. And of course, all these aspects have to be adhered to through this comparative assessment and harmonization exercise. Some of the other key points to note, and of course, the upcoming slides are more about few pointers, important pointers for discussion's benefit. So on this slide, what you see is employee versus worker. So the codes have brought a distinction between employees and workers. Both are, of course, defined. Employee is an all-inclusive concept. I can see a question in the chat box about professional employees, professional personnel, how they are going to be treated. So I'll cover that point, but there is a distinction between employees and workers. Employee is an all-inclusive concept which will be relevant for regime on social security contributions, minimum wages, gratuity, etc. Now, worker, on the other hand, refers to non-managerial workforce and would be relevant specifically for regimes from the viewpoint of industrial relations, such as industrial disputes, retrenchment, layoff processes, closures, provisions related to working hours, leave entitlements, etc. Moving on to the next slide, just to highlight the point here, because the term which is being used even for enforcement officers is inspector cum facilitators. Of course, when the codes were being written, the concept was really on having facilitators only, but somehow that enforcement capability is required to be retained. So we have seen legislature now specifically calling these enforcement officers as inspectors cum facilitators. So the earlier level of framework had comparatively minuscule fines, very slow enforcement. These entailed lengthy litigation proceedings or conciliation proceedings. Now, the courts tend to improve this position by prescribing enhanced monetary penalties and the option to even compound offenses. So employers can admit the violation and pay a set amount, I mean prescribed amount upfront, which would be anywhere in the range of 50% to 75% of the maximum fine, which is payable in case of non-compliance under the particular section. This may tend to bring in the avoidance of years of litigation or facing prosecution by the competent authority. But just to bring in that word of caution, compounding as such is not available for repeated offenses, which are there or which are there in the within the last 3 years before the first compounding was carried out in relation to the same non-compliance. So that is something which you need to be mindful of, but compounding as a process has been clearly stipulated under the codes. So with that, we bring the presentation to an end. Happy to address the questions. My colleague Diksha is there. She has been collating some of these questions, and we are happy to take it up based on the subject it deals with.
Am I audible, sir?
Yes, Diksha, we can hear you.
Okay. So I think one question that we have received is what about the specifics of the grievance redressal committee? What kind of grievances can come within the purview of this mechanism?
Abhinav, you want to take it?
Sure. Sorry. So the grievance redressal committee, any grievance which are related to employer-employer, employer-employee, and between the employee-employee would form part of this grievance redressal as committees would be subject to grievance redressal committees purview. And yeah.
So just to add to that,
Basically,
to bring in a bit of a, I would say additional nuance to it. This is not something which pertains to anything which has a disciplinary angle. Largely from the viewpoint of individual grievances in the nature of service disputes, anything which is in relation to, let's say, claims of potential discrimination, nothing as such has been really listed out, as Abhinav has already mentioned. It just talks about the inter se parties amongst whom some of these grievances may arise. But largely it is meant to address specific service or terms and conditions related grievances. It is not something which is emanating from the disciplinary point of view.
The next question is about professional employees such as doctors, right? Who are engaged with more than one employer. Do the new labor codes expect that these should be converted into permanent employees or fixed term employees, or they can continue to be engaged as multiple establishment professionals. What's your take on that?
So I would like to clarify, the law does not talk about conversion. The law, even under the previous regime, there is nothing to demonstrate that under any circumstances for professionals, and I'm talking about medical practitioners who are engaged as consultants or retainers in various hospitals. Most of the time, there are empaneled to serve in different hospitals. Now, in those cases, it is not a specific requirement under any of these codes which we just referred to have them converted into permanent employees, or you revoke the retainership relationship, or their engagement as consultant. That's not the intent of the law. But of course, if there is any employer-employee relationship, the law would of course talk about ensuring that you are considering these practitioners, if they're engaged as employees under any scenarios, to be at par with the regular workforce, especially if they are engaged on a fixed term basis. So all those benefits which are accruing to a regular employee will be also considered for the medical practitioner if he or she is engaged as an employee. So there's no conversion requirement.
Got it. Abhinav, the next question is for you. Does garden leave count as active service period for calculating eligibility and contributions towards gratuity, provident fund, and other benefits?
Yes, because garden leave is nothing but just an extension of your, it's just your notice period. You were supposed to work for operation reasons, and employer had asked you not to report to work. But that doesn't change any employer-employee relationship. You are supposed to, you are active in service. Even the insurance, apart from gratuity PF, even the insurance would also be applicable for that period. So for all purposes, an employee would be considered on the rolls until the expiration of the notice period or the garden leave period, which extends during this notice period.
All right. I think next question was already addressed by Anshul, which is whether dual employment can be considered acceptable, but still any other nuance that you want to add?
No, I think one nuance will be to ensure that conflict of interest ought to be avoided. Especially, I'm talking about engagement of professionals in capacities in more than one establishment. And of course, the whole aspect of declaring any confidentiality obligations specifically required to be complied with, all that will continue to coexist. So the law does not really tend to undermine some of these critical requirements from an employer-employee or service recipient or service provider relationship perspective. But otherwise, dual employment, at least in this regard, which Diksha was referring to, is not specifically prohibited. For factories, of course, there is a nuance to it, but otherwise, the kind of relationship we are referring to, there is no express prohibition which we have come across.
I think next question, any one of you can pick up. Is there any limit on the number of fixed term employees an employer can engage under the labor codes?
There is no limit as such, but just ensure that when you say fixed term employees, then in essence, they have to be fixed term. Just don't continue to engage them year after year and say that they are fixed term employees. I think earlier the premise was that gratuity as a concept may not apply to them, but be mindful that both Code on Social Security, which Abhinav has already covered this point, and the Industrial Relations Code for workers as well as other employees, the benefits would apply to them. So if one is looking at probably obviating the possibility of these benefits accruing to fixed term employees, that's not going to be the case anymore. So in essence, if ultimately the relationship is meant to be more of a regular employment relationship, then please reconsider how you are engaging these personnel. But otherwise, there is no limit on having fixed term employees.
So if you want to add one fine nuance about the Maharashtra IR code, which is in draft form right now. So if you want to add,
No, please go
which has
ahead.
certain restriction. Sure. So, I mean, that's just in the draft form right now. The IR code have a restriction on number of FTs in a particular category, but they have not been
Yeah, but
notified
we
as of
cannot
now, as
say
we all know.
anything with certainty right now. That's
Correct, yeah.
why, because this is still in a draft stage, much of it needs to be seen how these specific conditions are going to pan out. But under the law, under the substantive law provisions, as such, there is no restriction which has been placed.
I'll take the next question now. Um, As per the new wages code, what is the wage to be considered for leave encashment and overtime computation? I think we already covered it, but if you want to just quickly summarize that.
So I think wages definition is uniform. There is no expressly excluded component for the purpose of this computation. When it comes to leave encashment, again, the way we have explained, you have the included components, and please do not focus only on basic. It is basic and any other components which are ordinarily payable to an employee as promised payments. There are excluded components which are also provided. So a sum of those included components and excluded components like HRA, conveyance, all of that taken together will be your remuneration. And when it comes to computing leave encashment, please ensure that you are computing it at least on 50% of the total remuneration. But be mindful that if your wages are already above 50% threshold, then you have to compute it on the actual wages. But the threshold is 50% of the total remuneration, not the cost to the company. I again want to clarify, CTC is not the critical factor or point of reference. CTC can entail many other aspects, any other expenses which you may incur, including insurance premium, but that's not something which is of relevance for the purpose of computing payouts like leave encashment.
I'll also now take up the questions that Anvesha had previously shared with us. One of which is there any exemption for any particular industry, or the labor codes are expected to apply to all employees and all industries?
We haven't really come across any specific exemptions. In fact, these codes are quite inclusive. And the only difference one could see is about appropriate government for certain sectors, but largely for private enterprises, private sector establishment, the appropriate government will be the state government, specifically on the OSH code. For central, the code on social security will have the central government, which will bring out the schemes to substitute the existing social security framework. But yeah, I mean, there is nothing as such which is otherwise bringing out a particular exemption.
And in terms of how we can plan the alignment exercise vis-a-vis labor codes, are there any few action points that you can recommend to be implemented right away? And are there any provisions which are dependent on notifications and rules which we cannot really align with at this stage? So if you can give that insight as well.
No, so I think on the preparatory side, I'm not even going at the procedural nuances bit, but to the extent we are aware that the wages definition is very much there, and if you have to compute some of those payouts for your employees, have a look at the salary structure, see how those computations have to be made, specifically on the gratuity front, because you may have significant exposure. If at all there is any requirement for you to have potential revisitation of some of these components, the quantum of these components, to see if at all you are able to bring the wages at par with the 50% threshold, you can consider that as an exercise. And most importantly, the harmonization exercise or comparative assessment, which I was referring to, because now you have two parallel regime on overtime, spread over leave entitlements, etc. So just be mindful of doing that, because while there is not much visibility on how things are going to unfold when it comes to rulemaking exercise by the central government and state governments, But it is also important that the industry continues to carry out some of these exercises at their end, because ultimately the compliance framework will be applicable to you under both of these regimes. And when it comes to standing orders, these are yet to be notified as effective, but please be mindful that you are going to be covered even as a commercial establishment under the standing orders regime. You don't need a special notification for coverage. So that is something which you ought to look at, largely from the viewpoint of harmonizing your existing disciplinary framework, which is applicable to people in the worker category or non-managerial category. Similarly, for grievance redressal mechanism also, please be mindful that whatever you had as an existing mechanism is not going to be sufficient. You need to have this mechanism in place, which is going to comprise of representation even from the worker side. Of course, we need to depend on some of the rules which will come into picture under the IR code when it comes to selection of these worker representatives, but nevertheless, be prepared that this is going to be a requirement. Another important point is about looking at your current engagement structures, especially engagement of outsourced workforce for some of the core activities, whether you can fall within the purview of some of these exceptions which I was referring to. That will be of critical importance. I'm not saying you do a policy overhaul. I'm not saying that you just revisit each and everything which you already have in place. The registrations and licenses which were earlier issued, some of the notifications that were previously issued, until these are substituted by the rules and the notifications which are to be brought out by the central government or the state government under the applicable codes, please continue to rely on those registrations. But be mindful that there could be additional information requirements which will come into play. So this is more of a preparatory angle, but don't be dependent on rules completely, because that is more on the process, that is more on the threshold, but substantive law is very much there, as I referred to.
Abhinav, there are two questions for you. One is in relation to gratuity. What will be the impact of the new labor codes on gratuity calculations for existing employees?
Sure. This is one of the most talked about subject from a financial implication standpoint. So in the erstwhile scheme, gratuity was calculated on basic wages and dearness allowance, correct? Basic could have been 20%, dearness allowance was a minuscule part of your total remuneration, just to meet the cost of living index, right? So gratuity could be anywhere which typically below 50% or whatever, but was a minimum part, mainly dependent on basic wages. Now, what Labor Codes has done and what Anshul had elaborated on that particular attributes of the definition of wages, it will come into picture. And that's one of the most important concept across all labor codes. What it says is that if your excluded components exceed 50% of your total remuneration, then your wages would be deemed to be at 50%. Now, erstwhile you were calculating, let's say at 25, 30, 35, 40, but now you would have to calculate at bare minimum 50%. That is one. And if your wages bucket is above 50%, then it would be like, let's say it's 70% of total remuneration, then it would be calculated on 70%. Now, this is one important aspect which the industry at large is grappling with. Okay, and there is lack of clarity. While the erstwhile notification of 20 lakh rupees continues to apply, there is no deviation from that. But industry at large is wanting to understand how they kind of harmonize the erstwhile scheme with the new regime, because it is very clear, like Anshul also mentioned, that from 21st of November, the new codes have come into picture. The wage definition is independent. It will apply irrespective to irrespective for your computation of PF, gratuity, retrenchment, so on and so forth. Now it has to be calculated on the new definition of wages. And what many employers are doing is that if they have to kind of provision it, they are just waiting for a couple of these few months until there is more clarity. And pursuant to that, the gratuity would have to be paid at the new concept of wages, in nutshell.
All right. Um, there's one more question for you, Abhinav. Maybe I'll take a pause and there's a lot of questioning around wages definition. So maybe Anshul, you can pick that up. So what is your take on one-time payouts like joining bonus, notice pay, sales incentive, which are not exactly paid month on month, right? So what is your take on those payments? Do you think that those will form part of either wages or expressly excluded components or in this entire 50% remuneration assessment?
No, so anything which is of contingent nature, which is subject to conditions being met or parameters to be complied with by an employee, will not even form a part of those excluded components, because we have a specific list under the definition of wages where we have these excluded components clearly set out. And if none of these uh, factors are really coming in, or constituents coming into that expressly excluded component list, then we have to look at it from the viewpoint of contingency or conditionality attached. Notice pay, of course, is not a special payment. Notice pay is essentially a salary which you pay to an employee while he's already in your employment but has resigned or has been terminated from service, and pursuant to the terms of agreement, he is going to earn that amount as part of the ordinary cycle. It is not a special payment which is otherwise due to an employee, subject to him complying with some of the special requirements. So I don't think you can take that notice salary out of the purview, because ultimately it will be considered as wages which will be payable to an employee at the time of his exit. And that is where this 2 working days time frame also comes into play. But otherwise, any other payouts, including sales incentives, long-term incentive, ESOPs, RSUs, the value of it, all of it will be falling outside the purview of remuneration.
All right. So Abhinav, back to you. There are a lot of questions being asked on gig workers and platform workers. I think we should clarify whether these are even applicable to the industry at large. Because one of the questions is that if a company is newly incorporated, how should it contribute to the fund? After the creation of the fund, how will gig workers receive benefits? How will the amount be remitted to them? So there are a lot of questions around it, but I think helpful to clarify that it's not really applicable to the industry generally. It's for very specific categories of establishments. So maybe you can take that up.
Sure, sure. Thanks, Diksha. You answered half of it, and I'll complete this part. So there is a specific definition of what an aggregator is under the code, so that it is applicable only to those specific industry. There is a schedule like your food service apps, like your service related apps like your Urban Company, your Zomato, your Swiggy, if I have to just name. So it is only for those kind of establishments or those kind of employers this gig worker concept has been introduced. I believe, and correct me if I'm wrong, Diksha, only two states have kind of even notified these rules and the schemes under that. And for the industry like yours, this would not become really relevant. What under the codes and what Anshu really covered was that important slide on sales promotion. That is more important from your industry perspective, but with regard to gig workers, it is not really applicable, because there is a proper schedule. Who's a who's an aggregator, where there is a marketplace, the aggregator is there, the end consumer is there, and how the facilitation process is organized. It is applicable only to those kind of establishments or to those kind of service providers.
And just to add, ultimately, the larger aspect of gig workers, the way it has been referred to under Code on Social Security, is not to recognize them as part of regular workforce. There is no deemed absorption. What the law is essentially recognizing is the concept of extending social security benefits to these personnel. And just to clarify, at the central level, The schemes are yet to be framed. The mechanism is yet to come into place. And of course, if at all in the future there is a specific notification to expand that list, which is already provided, then one has to see how it plays out. But even from the perspective of extending those benefits, unless and until at the central level we see those schemes being framed and implemented by the central government, this concept is just recognized, but you're not really required at this stage to provision for any expenses for gig workers.
Absolutely.
There is one question, Anshul, on 50% capping with respect to wages in kind. And the question is whether things like company car EMI, driver salary reimbursement, petrol reimbursement, insurance premium, would all this be considered as wages in kind, or there is some other construct to it?
No, so I'll quickly dispel that that misconception. Company car and some of these other aspects are perks. They are specific emoluments which are set out for employees. I'll give a quick hypothetical example of payment in kind. People who are working on plantations are being paid in the form of, let's say, 2 sacks of rice and pulses to cover some of the elements which are otherwise payable in cash. By or you talk about specific, let's say some kind of a jewelry which is being paid month on month or on a quarterly basis by the employer. And what really is provided for under the law, under the code on wages, is to discredit or discourage employers from engaging in those practices. So if you wish to have or engage in such practice, even if you are able to justify or if you want to justify that I was supposed to pay 100, but I paid only 50 in cash, rest of it is the value of these goods which I'm providing to the employee, then for that 50 rupees, the balance 50 rupees, you can only claim up to 15% as the total value, which could be considered as part of the wages. Rest of it is something which you ought to fulfill as shortfall. But company car and all these aspects is not payment in kind.
I think maybe I can take up the next question, and Abhinav, you can supplement it as well. Actually, no, this is with respect to OSH code, so Anshul, you can supplement. So the question is whether services of a cook for a nursing hostel are needed for 2 hours on a routine basis, who is hired on an individual contract agreement, that would meet the requirements of a written appointment letter. So I think the question is with respect to a cook which is being engaged in a nursing hostel. So would you like to take that up, and maybe I can help supplement if needed?
I mean, see, much of it would depend on what is the basis, what is the frequency. If this was very incidental, piecemeal engagement, there are provisions under OSH code which deal with engagement of people in different capacities on different basis. So if it is a piecemeal worker, then of course OSH provisions are going to be applicable. Appointment letter is something which is not really coming forth as an exempted requirement for, let's say, a piecemeal worker. Nevertheless, you have to capture that understanding if you are engaging somebody as a piecemeal employee. But if this is absolutely incidental, or this is some senior person who's coming in for on a specialized basis, very, very incidental, just maybe for a couple of hours on a particular day, let's say in a particular month, then we'll have to see how that arrangement could be really executed. But if this is on a regular basis and the person is coming and being deployed on the premises, then of course you have to determine that relationship through an appointment letter. You can add Diksha from your end.
Yeah, I think, and in any case, we will have to also keep in mind the applicability of OSH code as well. So in a nursing hostel, of course, if it's a premises where certain business occupation is being carried on and it has 10 or more workers, that's when the applicability really kicks in. So subject to that, of course, the requirement of written appointment letter may also become applicable, and that's not really distinguishing between how the individual is being engaged. So I think you've covered that. I think we have already addressed the next question, which is car EMI, driver salary, petrol, etc. would be considered as 50% exclusion. So I think just to reiterate, when we say 50%, it's only with respect to remuneration. So wages have to be at least 50% of the remuneration, else the law will deem it to be that. And in that entire assessment, we are not going to consider reimbursements at all, whether as part of wages or as part of expressly excluded components. All these other aspects like car EMI, driver's salary, these aspects are over and above the remuneration bucket. And this will be part of the CTC of the employee, of course, but nothing that needs to be considered for the 50% wage assessment. And same for insurance also. I just got that prompt. So even for insurance premium, that's a cost that the employer is incurring vis-a-vis the employee, but it's not part of wages or expressly excluded components. So these are not to be considered for the 50% remuneration assessment. Yeah. I think I've got a prompt that we'll have to wrap it up now. So Anshul, Abhinav, just last words from both of you.
No, I think, sorry. So I think, first of all, thanks so much for this opportunity. And we just found these questions very intriguing and I would say very insightful from our side, because for us to provide some insights, the questions also need to be insightful. So that was great to have you all putting forth all those queries. I just wanted to express my gratitude and also just feel free, because this session was just meant to provide some further clarity, dispel some of those misconceptions, but anything specific which you require, which is of course relevant to dynamics of your own organization, feel free to reach out. We are happy to address those queries. Our articles are all there. If there is anything specific which you need, the team is always there to render whatever assistance possible under the codes. And of course, as we move along and as we see more clarity on the rules front, then probably we'll come back again and set forth some further sessions on a more specialist basis to clarify how the procedural nuances are eventually going to pan out for the industry.
That's wonderful, Anshul. Thank you, Anshul, and thank you, Mr. Rastogi, for taking out time. I mean, the entire session has been so enriching. It's tremendous learning experience for, I think, for the team in NATHEALTH, as well as the people who have joined. So thank you, everyone, for taking out time. This has been a very important topic for discussion. And, I've been getting questions if the deck that we are presenting today can be shared with the audience. If we have your permission, maybe we can share with the participants. There are more questions flowing up, but I've just requested them to email me the questions and I can forward it to both of you and you can respond to that. Okay?
Sure, no problem. And the deck can be shared. No problem.
Okay. So thank you, everyone, and have a wonderful evening ahead.
Thank you all.
Bye-bye.
Thank you.
Thank you. Thank you.
You disconnect.